Thank you. Honorable Ms. Justice Geeta Mittal, former Chief Justice, High Court of Jammu and Kashmir and Ladakh, and Chairperson Vulnerable Witness Committee constituted by Honorable Supreme Court of India. Honorable Mr. Justice Sanjay Dhar, Judge, High Court of Jammu and Kashmir and Ladakh, and Chairperson of the Vulnerable Witness Deposition Center Committee for Union Territory of Jammu and Kashmir. Honorable Mr. Justice Puneet Gupta, Judge, High Court of Jammu and Kashmir and Ladakh. Honorable Mr. Justice Mohammad Akram Chowdhary, Judge, High Court of Jammu and Kashmir and Ladakh, and member of the Vulnerable Witness Deposition Center Committee for Union Territory of Jammu and Kashmir. Honorable Mr. Justice Rahul Bharti, Judge, High Court of Jammu and Kashmir and Ladakh. Honorable Mr. Justice Rajesh Sekhri, Judge, High Court of Jammu and Kashmir and Ladakh, and member of the Vulnerable Witness Deposition Center Committee for Union Territory of Jammu and Kashmir. Officers of the Registry of Vulnerable Witness Committee constituted by Honorable Supreme Court of India, officers of the Registry of High Court of Jammu and Kashmir and Ladakh, judicial officers of both Union Territories joining physically and through virtual mode, officers from the Civil Administration and Police Department, legal aid lawyers, architects, officers and engineering staff from Public Works Department, participants, ladies and gentlemen, my respectful greetings to everyone. It is my extreme honor and privilege to extend a warm reception to everyone participating physically and through virtual mode in this training program on conversion of courtroom into Vulnerable Witness Deposition Center, being organized by the Honorable High Court of Jammu and Kashmir and Ladakh in association with Jammu and Kashmir Judicial Academy under the aegis of Vulnerable Witness Committee constituted by Honorable Supreme Court of India in this city of temples, nestled on the banks of the sacred river Tavi in the pristine backdrop of Shivalik and Trikuta ranges. Ladies and gentlemen, plants are eternal gifts of nature and signify growth. Today, they are also symbolic of warmth and our reverence for the honorable dignitaries. I request Madam Bala Jyoti, Special Judge Anti-Corruption Court CBI Cases Jammu, to please honor Honorable Ms. Justice Geeta Mittal, Chairperson, Vulnerable Witness Committee. Thank you, ma'am. I request Shri Sanjay Parihar, Principal District and Sessions Judge Jammu, to please honor Honorable Mr. Justice Sanjay Dhar, Chairperson, Vulnerable Witness Deposition Center Committee for UT of J&K. Thank you, sir. I request Shri Yashpal Kotwal, Principal District and Sessions Judge Samba, to please honor Honorable Mr. Justice Mohammad Akram Chowdhary, Member, Vulnerable Witness Deposition Center Committee for UT of J&K. Thank you, sir. I request Shri Haknawaz Zargar, Principal District and Sessions Judge Udhampur, to please honor Honorable Mr. Justice Rajesh Sekhri, Member, Vulnerable Witness Deposition Center Committee for UT of J&K. Thank you, sir. May I now please request Honorable Mr. Justice Sanjay Dhar, Chairperson, Vulnerable Witness Deposition Center Committee for UT of J&K, to present the welcome address.
Honorable Justice Geeta Mittal, former Chief Justice of our High Court, my brother judges on the dais and off the dais, dear judicial officers, engineers and architects, staff and other participants who have joined us physically and virtually. Good afternoon to all of you. Today, I feel extremely privileged to have been given the opportunity to welcome our chief guest, Honorable Miss Justice Geeta Mittal, the Chairperson of the Supreme Court Appointed Committee, and our former Chief Justice. I, on behalf of the High Court, welcome you, Madam, and express our deep gratitude for accepting the invitation and taking time out of your packed schedule for this event. We sincerely hope that today's program will hugely benefit all the participants and the stakeholders. Honorable Justice Geeta Mittal does not need any introduction, especially in this part of the country. As we all know, he has been our Chief Justice and has been by far the most popular Chief Justice our High Court has so far had. Our work, both on judicial side and administrative side, is being acknowledged and appreciated by one and all. Our connect with the people of this region, especially with the judicial officers and the staff, has been so deep and personal that even now all of us feel her absence. But the fact remains that she is and will always remain in our hearts. Honorable Justice Mittal's presence today amongst us gives us immense pleasure for the reason that the event which is going to be held today is with regard to the vulnerable witness deposition complex, idea of which is the brainchild of her lordship. Now, this idea was conceived by her lordship and brought to our country. The scheme has been introduced not only in our union territory, but in whole country by her lordship. It was under her lordship's guidance that vulnerable witness deposition complexes became functional in certain parts of this union territory like Srinagar and Samba, which are fully functional even today, and even makeshift or temporary complexes of similar nature are functional in some other districts of the union territory as well. We are extremely fortunate to have your lordship amongst us to guide us in implementation of the scheme. I once again welcome your lordship. I also welcome my brother judges, Justice Puneet Gupta, Justice Akram Chowdhary, Justice Rahul Bharti, and Justice Rajesh Sekhri. Without their invaluable inputs and cooperation, this event would not have been possible. Last but not the least, I welcome the judicial officers, architects and engineers, and other participants who I feel would feel greatly benefited with the valuable guidance which they will be getting upon undergoing this training session. The purpose of this training program is to sensitize us about the special needs of a vulnerable witness, whose definition has recently been expanded by the Supreme Court to include not just those below the age of 18 years, but also sexual assault victims, regardless of their gender, besides those suffering from mental illness, a witness having threat perception, those who are hearing impaired or have any other disability. The Supreme Court has directed that use of VWDCs could be allowed even in cases of civil jurisdiction. This important direction has been passed by the Supreme Court in April this year on the basis of a report submitted by Honorable Justice Mittal. Our High Court has also framed guidelines for recording deposition of vulnerable witnesses based upon the model guidelines circulated by Her Lordship. The object of setting up a vulnerable witness deposition complexes for recording deposition of vulnerable witnesses is to promote a sensitive response of judicial system towards such witnesses. So all of us have to work together for achieving this object under the able guidance of the committee headed by Honorable Justice Mittal. At this juncture, I would like to remind that all of us who have been trial judges have experienced it at some point of our career that prejudice and travails a vulnerable witness goes through when goes in normal courtrooms. I would like to illustrate some of the examples which I have gone through. As a sessions judge in Rajouri, a victim of sexual assault came to depose before me, as most of us do in traditional courtrooms. I made her comfortable and offered her chair on the dais. Something transpired between the victim and the accused, which I could not gauge at that moment. The victim told me that she is not comfortable, she will depose after lunch. I allowed her to go. I told her, yes, we will record her statement after lunch. After lunch, when she deposed, she falsified the prosecution's story, turned hostile. I was not aware what has happened in between. But later on, after a few days, I came to know that she was scolded and she was tortured by the accused outside the court complex. This is what happens in traditional court system. Another incident I am reminded of, I was judicial magistrate at Jammu. One victim in a 354 case came to depose before me. The moment I started recording her statement, we received a call from Chief Justice's office that you have been called. So I went there. There was some issue. After about 1 hour, I came back. I inquired from my reader. He said the witness has gone and the accused is also not present. So I joined the case. But in the evening, the reader told me that the victim was scolded by accused when I had gone to the High Court, and she vowed that she will never come to court to depose. So this happens in a traditional courtroom when we pit this accused against the victim in the same courtroom, and there is no barrier or screen between the two. So keeping these difficulties in view, the importance of vulnerable witness court complexes becomes extremely important. With this idea, this present training course, which we are holding today, has been organized under the guidance of the Supreme Court monitored committee, Supreme Court appointed committee. The idea of getting participation of the architects and engineers is to make them aware about the requirements of vulnerable witness deposition complexes so that they design and construct these complexes as per those requirements. I hope and trust that they will also get greatly benefited by this program. I also request all the participants to clarify their doubts by interacting with the Honorable Chief Guest and clarify all their queries and doubts which they may have in their minds. I hope I am not taking too much of your time, and now, without becoming a barrier between you and Honorable the Chief Guest, I would request Swati ji to proceed ahead with the program. Thank you for being a part of this wonderful event. I welcome you once again. Thank you.
Thank you, Lordship. Lordship's visionary guidance shall certainly lead all of us on a progressive march towards the effective establishment and functioning of vulnerable witness deposition centers. Ladies and gentlemen, the courtrooms across the two UTs of J&K and Ladakh are witnessing a great transition in terms of facilities being provided to witnesses of vulnerable nature. We are fortunate to have the kind presence of Honorable Ms. Justice Geeta Mittal, Chairperson of the Vulnerable Witness Committee constituted by Honorable Supreme Court of India, for guidance of all stakeholders involved in the process of conversion of courtrooms into vulnerable witness deposition centers. I very humbly request Honorable Ms. Justice Geeta Mittal for her enlightening presentation.
ये पॉइंटर किस लिए हाँ किस लिए है ये अच्छा स्लाइड टर्न इस राइट साइड ओके My very respected and dear brothers from the High Court of Jammu and Kashmir, Principal District and Session Judges present here virtually and physically, my brother and sister judges of the Judiciary of Jammu and Kashmir, lawyers of the legal who are helping the litigants and the courts in and are rendering legal aid, Mr. Rajesh Gupta, Mr. Mohd Mahajan, Chief Engineers in Jammu and Kashmir, officers from the civil administration, police officers, architects, officers and engineering staff from the Public Works Division, officers of the Registry of the High Court, especially those who are part of the Vulnerable Witness Deposition Committee, officers of the District Judiciary. Namaskar, Sat Sri Akal, Assalamu Alaikum Salam, Jule. I have taken these greetings from you, learned them from all of you, and I've carried them across the globe. I have yet to open an event in the past 3 years, even after I left Jammu and Kashmir, without using these 4 greetings. I would like to tell you that you are a part of a very important, significant part of India, which is actually almost a mini India in itself. There is no state or union territories in the country which can boast of so many languages, so much diversity, cultural, linguistics, clothing, food, as the union territories of Jammu and Kashmir and Ladakh can. And these greetings are so inclusive. You know, they're not segregated by time. You don't have to say good afternoon, good evening, good night, or good morning. These are valid at any time of the day, and they reach out to everybody. So Sanjay, Dhar, my very dear brother, I can't stop calling him Sanjay. I've known him when we were both lawyers practicing in the High Court of Delhi many, many decades ago, almost 30, 40 years ago. You know, he's laid out the roadmap of what I'm going to say. I had proposed on a timeline, but I think we are beyond that time. I have a PowerPoint presentation, which I'll just explain to you in 2 minutes. For our friends from the engineering department, the architects, and the police, the initial part of the presentation may not be of great relevance, so you may find it not as per what would interest you. But I will come to our video which will assist you in appreciating and understanding why this training and why this program is so significant and important. So I'm very grateful for your presence here. Officers of the level of chief engineers are with me and with us, and which shows how much importance is attached to the work of the judiciary by the officers, the administration, the engineers, and the architects in these universities, in this in these union territories. So we are all aware as judges. I must tell you, it's extremely heartening. I go back to the days when I used to hold VCs with you, all of you in your courtrooms and your court complexes, and interact with you. It's a real pleasure. I would wish I could see more of you, those of you who have joined virtually. And I will go back on in the recording and check who will and try and see how many of you I can still recognize. But for me, it's extremely heartening, and it is a very momentous occasion for me to be standing before you and addressing you on this topic, which is very sensitive, very important. And after Delhi, I was able to implement it in Jammu and Kashmir, which is also a story which I've carried across the country in the trainings which I'm carrying under orders of the Supreme Court. Now, we are all aware that the criminal justice system is concerned with largely the rights of the accused. Witnesses are completely buried, whether it's in the civil or the criminal system, even though they are called the eyes and ears of the court. And victims are very seldom thought of. There is a growing attention being paid to the rights of the victim, compensation, medical treatment, etc. But it wasn't always so, as Justice Dhar has pointed out in the traditional courts. Historically, let me give you a few, sum it up in 4 or 5 sentences, how I got attached to this program. I was primarily a civil lawyer from 1981 till 2004 when I went to the bench. I'd done some criminal cases, I had done murder trials, I had done 498A cases, I had done 107, 151 Muchalkas. There's not much that I hadn't done, but I would not touch a case involving sexual violence. I wouldn't take rape. Somehow, morally, it seemed wrong, to be not defending a victim, a criminal who was accused of committing rape. The fact that the accused is entitled to a fair defense never was not of as much importance as the revulsion which one felt in having to defend such a case. In 2008, I was sitting on the criminal jurisdiction in the High Court of Delhi, and I got this case where the legal aid lawyer was insisting that I hear the appeal. It was an appeal against a conviction for rape under 376 of the Indian Penal Code, Ranbir Penal Code for you people then. And definition of rape was identical. It was penetrative sexual assault. And I asked the lawyer why he was so confident. It was an 8-year-old victim who had accused a 19-year-old boy of having raped. So when the legal aid lawyer presented the facts, it transpired that in recording the statement under 161 of the CRPC, that is in first level statement, during investigation, the investigating officer had recorded that the accused had done galat kaam to the victim. In the statement recorded by the magistrate during investigation under section 164, the magistrate had recorded buri harkate and without bringing out the ingredients of the offense. And to top it all, during trial, the sessions court had been as negligent and had recorded an equally innocuous statement as, you know, kuch galat kaam or kuch, I can't recollect now, buri harkate or something. But when the magistrate, the sessions judge during the trial had realized that this was not sufficient, so she had asked the victim what she meant when she said buri harkate or galat kaam. So the victim in answer had said that the accused had done what a husband and wife do at night. Now the judge was probably embarrassed and didn't ask further as to what the witness meant by this statement. And the only statement which came in record were these 3 statements, 2 during investigation, 1 during the trial. Of course, I had to acquit because the ingredients of the offense had not been made out. But what this case showed was the embarrassment which the police officer felt in taking the evidence in a rape case, the embarrassment which a magistrate felt in dealing with the statement relating to sexual violence of the nature of rape and recording what was needed by law, and the trial court, which was the sessions judge, was equally embarrassed. So, Benjamin Cardozo, the famous Chief Justice of the Supreme Court of United States, has said that we are all judges are also products of their upbringing, of their education, of what they have lived with. And we in this country are not comfortable, not on, in dealing with issues involving sexual activity, whether it be law teachers in law universities, who brush over lessons relating to the sections relating to rape, whether it be magistrates, police officers, or the judges, everybody is embarrassed about talking about these. And the second thing it showed was that this was a Tamil child. When I looked through the entire evidence to see whether she could know what a husband and wife do at night, presuming that there was only one thing that happened. I looked at the evidence, and her father, who was a driver, in his statement, it had come out that this family was a broken home, and the child's mother had deserted the husband and child when she was a baby of few months. So obviously, this a driver living in a one-room juggi could not have known what a husband and wife do in the night. Certainly not the relationship which was being adverted to. So I had to acquit. The second thing they showed was it was a Tamil child. Now we don't know. Delhi is cosmopolitan, so the judges, the magistrate, and the session judges came from different parts of the country. The the investigating officer was an officer from Haryana. This child was Tamil. We don't know what language she was, in which language she was giving the statement. So in my judgment, I talked about linguistics, language, as a barrier to accessing justice, and especially in a victim of sexual violence. And the second was judges being part of the community and the same social milieu as the ordinary man don't come differently. They have the same embarrassments. They have the same baggage which they bring to the bench, and they have to overcome that baggage to fight this. After I wrote this judgment, the Chief Justice of the Delhi High Court had appointed me as chair of the committee to look at the several guidelines which were available, which had been laid down by the Supreme Court and the Delhi High Court and other high courts in doing cases involving sexual violence, and to see how we could work them in Delhi. So it was a 3-year research from 2009 to 2012, which international research. I went to every single court in whichever country I visited to see what special measures they had, whether they had special measures, whether there was rules available, etc. And I researched from Zaire to USSR to Canada to New Zealand to England. I walked the criminal justice system, and I homed in. I was able to design this vulnerable witness deposition court, and with very simple modification in the existing courtroom. What I want to highlight, especially to the engineers and architects, is that you don't need new complexes, you don't need land, you don't need fresh buildings to convert or use any facility as a vulnerable witness facility. Secondly, these cannot be separated from the court complex, because this court will not be used for anything other than vulnerable witnesses. So if you are to put a vulnerable witness deposition court separate in an ADR complex, in a legal aid room away from the court complex, the judge will have to leave the court, walk and travel to a separate court to record the evidence of one witness. Not only the judge, the entire paraphernalia, your courtmaster, your helmet, the night court, the police, everybody will have to prosecutor, everybody will have to go to different complex. So this is what I want to highlight. And in Delhi, the first such courtroom we were able to create was on 16th September 2012. Between September 2012 and August 2018, when I left Delhi, all the 7 districts, six out of 7 districts, we had developed this facility. The judges said the testimony of the vulnerable witnesses was transformed, and certainly the outcomes were better. The biggest outcome which was good was the fact that the witnesses were comfortable. And we were able to segregate a victim completely from the accused while undergoing recording of evidence while in the court complex. Now, I would like you to understand why this special facility is required in the words of a psychologist. Dr. Achal Bhagat is a psychiatrist, psychologist in Delhi who has extensively trained judges. And you would please see a small clip which I've been able to record from Dr. Achal Bhagat. Second, leave the first slide. Judicial systems are preoccupied with the presumption of innocence of accused persons. The needs and interests of witnesses are generally overlooked, even though they are considered the eyes and ears of the courts. The situation is worse if the witness is a victim of sexual violence. What is the impact of testifying in court by a victim of sexual violence? Does it have any effect? On this aspect, let us hear Dr. Achal Bhagat, a mental health expert in Delhi who helped conceptualize and set up the vulnerable witness deposition complexes, as well as was a valuable resource person in the trainings conducted in Delhi between 2012 and 2017.
It is important to remember that a vulnerable witness may be re-traumatized during the judicial process. So the person needs to be protected so that they are not re-traumatized. Why should the person not be allowed to be re-traumatized? Because re-trauma means that the person relives the experience of violence. So it affects them psychologically. It causes them extreme anxiety. It may make them numb. It may make them not remember things accurately. What might cause re-traumatization? Any reminders that the person might get of the past when they were traumatized through the cues in the judicial process. And these cues could be simple. These cues could be the voice of the alleged perpetrator, the color of the shirt of the alleged perpetrator, the smells around the process, the way the questions are asked. The person might be pushed back into the same experience of trauma, and they might relive the trauma as if it was happening to them just right then during the judicial process. Now, one, it is not helpful for the judicial process to re-traumatize somebody. The very fact of re-traumatization means that the person is being harmed and it may cause disability. Two, it causes a lack of substantive equality in the process, because if the person is compromised because of their anxiety, because of their numbness, because of their inaccuracy in the memory, the judicial process itself is compromised because it's not equal in the same way. So the access to justice becomes an issue. Re-traumatization is not only for preventing psychological disturbance to the vulnerable witness, it is for ensuring access to justice.
So, Justice Dhar has already pointed out who is a vulnerable witness. This has been defined by the Supreme Court of India in the judgment in Smriti Tukaram Badade, which I will have my officers circulate to you. It was pointed out that it is not only children who have attained 18 years, age-neutral victims of sexual assault, gender-neutral victims of sexual assault, while referring to POXO, age and gender-neutral victims, as referred to in Sakshi, witnesses suffering from mental illness, witness deemed to have a threat perception, any speech or hearing impaired person, and you have the discretion to rule on who you want to treat as a vulnerable witness. The court has said any other witness deemed vulnerable by the court. So please freely scrutinize the witness in your court and decide whether you need to treat them as a vulnerable witness and give them special facility. Now, vulnerable witnesses originally were only in criminal courts. We thought that only victims of sexual violence. But children, for instance, could be in court in a civil or a criminal case, in a family matter, in a child custody dispute, victim of sexual abuse, in a paternity action, before juvenile justice boards, before the children's court. So, the persons covered under the definition of the vulnerable witness could be in any of these cases, and this facility at the orders of the Supreme Court can be used in all these cases for such witnesses. What is significant is that under the guidelines which we have suggested, the same facility is available not only to the prosecution or the plaintiff, but also to the defense or the defendant. So if the defense has a vulnerable witness, the same facility is made available. So far as children are concerned, they have special needs. Sometimes they may be the only material witnesses in cases involving sexual abuse. This is, I think, routinely you will find that in cases of child sexual abuse, they are the only witness. And also, they may be witnesses to domestic violence and crimes of other kind. This can be problematic as a child may be expected to depose against the father by a mother, and the child would be, and it is reluctant to take sides. This is what you have to address. Now, here is a slide. I hope you can see. This is the reaction of a child, just to tell you the innocence of the child. Black and white is to be seen either in the courts or on penguins. So, why is everyone dressed like a penguin? Is what a child witness asks. The legal systems are adversarial, we've already said, and the normal procedure prescribed by the Criminal Procedure Code or the Code of Civil Procedure was not designed. No special provisions are made for recording or providing for special needs of vulnerable witnesses. Now, so far as children are concerned, I am dwelling on children a little bit because you people must have noted difficulties or come across challenges in recording the evidence of child witnesses. They are not able to go to court, give a full and proper count because of the long wait between filing of the challan and their turn coming to give evidence. Court delays. As Justice Dhar pointed out, he had to leave the court and the witness went. It'll be worse if it's a child witness. Then multiple interviews, section 161 statement, section 164 statement, then the statement in trial court. Each time a child gives an account, there is bound to be some change, and that is what the defense is looking for. Then confronting the accused, facing an accused, whether it's an adult victim of sexual violence or a child, no difference. Cross-examination, use of age in inappropriate language in the court, interruptions by lawyers. This we are all aware. The moment a witness comes to a critical point, there is bound to be an interjection from the other side, and in a loud voice to overawe and subjugate the witness. Then you are arguing with the lawyer on admissibility of the evidence and the use of cross-examination designed to catch the witness out. This is similar. It's a continuation. I'll circulate this PPT, but honest answers by the witness. The child is saying, I'm trying to remember. I don't exactly remember. He will not be permitted to remember, and the defense lawyer will pounce and say, oh, he doesn't know. Let's have record kariye. ऐसे तो नहीं होता है. And then, this answer will also be used by the lawyer to say that the witness is unreliable. Then you ask abstract concepts. Do you know the difference between truth and a lie? This you should never ask a child witness. I will come back to you another time and do a whole session on how to see the competency and how to do a cross-examination. If the child witness had reacted, sometimes we record a lot as volunteered, in the cross-examination. But this portion, the defense lawyer will not let the witness speak. The moment he says, I put it to you, so gives a suggestion, and the witness says, yes, but will not be permitted to come. The lawyer will say, stop here. This is not fair. You have to permit the witness to give the full statement. And this was the witness's reaction. I'm upset that as a result, I could not tell the truth, the whole truth, and nothing but the truth, because the lawyer wouldn't tell him. Please remember that इसको नीचे ऊपर कर सकते हैं. Children are not miniature adults. And we tend to treat them as adults when they come to court. They cannot morph into being adults. So there are judgments galore on the fact that criminal justice system has a terrifying impact. The environment of the court, complicated legal procedures on vulnerable victims and witnesses. They don't have the experience. If you put ourselves in their shoes and imagine that we had to go to court and give evidence, you would be shaking in your boots. You would not sleep the whole night, even though you have been judges of 40 years, 20 years, 10 years. Then the confrontation with the offender, what Dr. Achal Bhagat pointed out, results in secondary traumatization. You see the accused person and you relive the trauma, the tension, the fear of what you have undergone. Then the environment of the court, it is so foreboding, it's so formal that, and the several judgments have spoken about the need to lower the dais. I will show you in the module that we have for vulnerable witnesses, deposition rooms, but we have lowered the dais, we've tried to use color and best interests of the vulnerable witness require concerns of the physical environment being addressed and sensitive treatment of the victim from the time they leave their home till we record their evidence. I'll share with you, the experience of Suzette Jordan. If I ask you, can you tell me what measures are provided by law which enable you to separate accused from a trial, from a victim or a witness in court? We are all aware of the judgments which say use a screen. Now, use a screen is very well, but the screen happens when the witness is called to give evidence. What about the time till the witness is in the court and the case is called out? The victim has entered from the same room as the accused, probably come on the same public bus to the courtroom. Accused and she may have had to been forced to be standing or sitting shoulder to shoulder in the public transport, or from the same courtroom gate, and then they are made to maybe sit or stand in the crowded corridors of the court. It's only when the evidence has to be recorded that you put the screen. Now imagine having to share space and be in such close proximity with a person the victim is saying has raped her, or has subjugated her to sexual violence. So the secondary traumatization of the victim has already happened, and certainly she will not be in a state of mind to give you a complete account of what has transpired. Now, the screen has been said to be the second thing which law permits. If anybody knows, they can raise their hand and tell me. In camera trials, the CRPC provides for a camera trial. But what happens in a camera trial? Is it sufficient? I'm going to share with you an excerpt of a statement by Suzette Jordan. She was a 35-year-old victim of gang rape. She was a single mother who had mother of two girls, and she was gang raped by a person who offered her a lift to her home. She knew the person, she didn't know the other persons who offered her. This is the very famous Park Street gang rape in Kolkata. Unfortunately, Suzette came for the trainings which I did in Delhi for 5 years. She used to come and she decided to go public because the police wouldn't record her FIR till 2 o'clock in the morning. Repeatedly, she was made to ask. Her medical examination was done in a very bad shape. The politicians in Bengal labeled her as a political, pawn. And the landlord told her to leave the house. She lost her job. So she decided to go public and not keep her identity concealed and speak up for rape victims. So I had her permission to use what she had said in the training. Unfortunately, she was infected with encephalitis and she died. But she died after she had given her evidence. And so 3 of the 6 accused got convicted, 10 years sentence was imposed. The 3 who were absconding had managed to go scot-free because Suzette is not there to be cross-examined. So I have an excerpt of Suzette's experience about a camera trial. मेरे को सुनना है.
In the courtroom, the complainant will always be one. or maybe two women. But if it's a gang rape, there'll be like, if it's 5 or 6 guys in a gang rape, then there are 6 lawyers. And their 6 lawyers have 6 assistants. And their 6 assistants have junior assistants. But the complainant has just 2 lawyers, max 3. 2 de factos, a public prosecutor. The very fact that she has to go in there, it's an in-camera trial. It has its advantages. It has its disadvantages as well. The advantage is it keeps you protected from public and more humiliation from the prejudiced, patriarchal kind of people. But the disadvantages is the victim has nobody inside the courtroom except her public prosecutor, who's really not her family friend. She's a professional doing her job. So it should not be the victim, because even in my case, I was told I could put a petition if I wanted somebody to be a support for me inside the courtroom. But there are thousands of girls, little girls, who are being raped, who are in the courtroom, and they don't know that they can avail of that facility. So no one will tell them, because I was told this. If I was told this, that if I get a lawyer, then I have to put a petition, the case gets prolonged, dates keep changing. Nobody wants that. So they don't even know that. So this order should come from the court. This facility should be given to the victim. Would you like a support system? Would you like your mother? Would you like your father? Would you like an extra person in that in-camera trial so that you feel safe? You expect a victim to stand there having the accused and then to narrate her ordeal and then be questioned and re-questioned. That, firstly, a rape is the murder of the soul. All these re-rapes completely murder the very mind, the little sanity that the victim has left.
So therefore, a camera trial is not the answer. We think we've given the victim everything by separating bleak from the court, but she's not separated from the real trauma, which is standing shoulder to shoulder with an accused in a crowded, small courtrooms, and being cross-examined by 1, 2, 3. In her case, it was 6, she said, 6 lawyers with junior lawyers, etc. But she stands there alone with not even a facilitator. So we have guidelines in India passed in a host of judgments. I collated all of them in the judgment which I told you about. That's a reported case, Virendra versus State. Justice J.S. Verma, who was appointed after the Nirbhaya rape in 2012 December, has quoted the judgment in almost 16 pages. And as I told you that we inaugurated the first vulnerable witness deposition complex in Delhi on 16th September 2012. Nirbhaya happened on 16th December 2012. So far as Delhi was concerned, so far as legal procedure and looking after the trauma of a victim of rape is concerned, we were already way ahead in addressing the needs of the vulnerable witness. So you have guidelines on every facet of a criminal trial, from the way the police has to conduct investigations, how the FIR has to be promptly registered, presence of a police lady officer, the medical examination, its conduct, magistrates regarding pre-trial statements under section 164 of the CRPC, trial judges during victim witness appearances and depositions, how they have to address, and the reintegration of the victims into societies. Just one question, brother. 164 CRPC was same section here earlier also. 161 also same. So they're able to understand, relate to what I'm saying. So I had to visit the laws when I was here. The acts and the difference in the provisions then applicable, but we have the benefit of the same laws now. Now, This is what you have to look at to minimize secondary traumatization so far as children are concerned. They have a unique requirement of language, memory, disposition, their cultural context. I said a Tamil victim in Delhi and the environment while asking the child for information. I have also a picture of Jolly LLB courtroom. Our courts look very similar, at least in the interiors. The crowded, you have lawyers speaking at the same time. So, the vulnerable witness courtroom has therefore was conceptualized and operationalized to overcome these several traditional disadvantages and barriers. It was guided by preventing any interface of the vulnerable witness with the offender or public exposure. You segregate the victim from the very entrance to the court complex, not to the entrance to the court, but from the court complex. And we have used technology, a very simple technology tool, a video link, and an intermediary to avoid a physical confrontation between the witness and the offender, court, and lawyers. And the best thing is that even judges who are not techno-savvy or not very technically literate as me can operate the system using the simplest tools which we have available with us. Your own laptop can be used to convert your courtroom anywhere into a vulnerable witness facility when you're recording the statement. The objective of the program, securing best interests of the vulnerable witness, which is critical in the words of Dr. Achal Bhagat, eliciting complete, accurate and reliable evidence. This is what justice will we be able to render if we are not able to get the best evidence from the witness. Minimizing the harm or secondary traumatization of the witness. So you minimize the harm not only to the witness but to the criminal justice system. You ensure non-discrimination, you ensure equality, fair trial to both the witness and the accused, and ensuring the rights of the accused to a fair trial. I'll now share with you a video of how an existing courtroom was converted into a vulnerable witness deposition room. This video will assist the architects and the engineers with us in understanding what can be done. You can do it in every court complex. The same room can be a room used for a normal trial. You can fix the days when you will record the evidence of vulnerable witnesses, and on those days use this ordinary facility as a vulnerable witness courtroom. Can we play the video?
The Vulnerable Witness Deposition Complex is an instance of judicial initiative and judicial intervention. It has been conceptualized to prevent secondary traumatization of vulnerable witnesses. The major difficulty being faced in creating the vulnerable witness deposition complexes relates to non-availability of resources. Finding land and finances to raise new complexes is a challenge by itself. For this reason, in Delhi, all such complexes have been crafted and developed by making minor modifications to existing codes and use of simple technology tools. All that is needed is a separate judge's entrance, a courtroom, its attached judge's chamber, an adjacent Ahmad's room or administrative staff room, some space hived even from a corridor for making a waiting room, a small toilet, and a small pantry area is sufficient. To illustrate, the following video leads us through the Vulnerable Witness Deposition Complex, which was inaugurated on the 16th of September 2012 in the Karkaduma Court Complex, Delhi. The complex allows for a separate entrance for the vulnerable witnesses through the judge's entrance, corridor, and elevator. This reduces the anxiety and shields the witnesses from contact with the accused, other litigants, lawyers, and the general public. A waiting room, pantry, and toilet have been crafted out of the corridor.
There will be very many complexes in Jammu, Kashmir, and Ladakh where you may not have a separate judge's entrance. So you will wonder what to do. So here you can craft the schedule of the case, scheduling of the case, so that the witness, vulnerable witness, enters the complex earlier than it's open to the public. Say at 9:30 in the morning instead of 10. So you bring in the vulnerable witness into the complex, into the waiting area. And so far what you have seen on the video, you saw the judge's entrance. Every district complex has a separate judge's entrance. So the judge's entrance is used and shared by the judges with vulnerable witnesses. Please go ahead. Now this corridor, you see the encircled, was used to craft out, even though you're not supposed to block the corridor, but a temporary door has been put there because you need to keep, in case of a fire or some disaster, the circulation has to be kept running. So this same corridor we have created this waiting area and the toilets. She'll just explain to you. Please go ahead. Uh-huh.
The vulnerable made available to ensure the comfort of the witness. As children may be prone to suggestion, it is ensured that there are no pictures or photographs on the walls. Technology tools here leads us to the corridor which was available in close proximity to the courtroom. Arrangement has been made for a computer, intercom, table, and chair for the court supervisor. A relaxed environment has been created in this area. Different kinds of furniture, toys such as carom, ludo, painting materials, stationery, plasticine, playing clay, etc. are provided. A washroom is also made available to ensure the comfort of the witness. As children may be prone to suggestion, it is ensured that there are no pictures or photographs on the walls. The pantry supplies filtered drinking water, facilities for making tea and coffee, a fridge equipped with drinks and fruits and adequate dry snacks for those waiting. If the case spills over the lunchtime, food is made available from the canteen. The existing judge's chamber stands converted into the deposition room, which has to be very close to the waiting area. It also provides for a very
पीछे ले जाओ उनको बोलो थोड़ा पीछे ले जाओ See, I also want to tell you that when I started I had made the plans and I called all the district judges and asked them to give me one courtroom each. They all laughed at me. They thought I was mad and this was a mad idea. Only one district judge the district judge Kakaduma, Justice P.S. Teji, then district judge gave me one courtroom. I needed the courtroom, I needed the judge's chamber, I needed space to cover the waiting area. I had no budget. This committee had no budget. So this facility was created with no budget out of existing infrastructure. So if you see the sofas and all, they're all sofas lying in the stores with the PWD or the court, in which we got them reupholstered. That's why you see this huge size. They're not any designer facilities. But what I'm trying to illustrate to you is you don't need budgets, you don't need space, you just need the assistance of PWD and a few electronic items like a mic and a earpiece to create vulnerable witness deposition courtrooms.
judge's chamber,
Which was converted. You'll also notice three kinds of seating. See, a child will not like to sit in a chair or a sofa. So we provided a carpet for the child. We provided a sofa for the adults, and we also provided a table chair for a victim who has got paper. Now, I didn't have a proper table and chair, so we have this small table with these two chairs there available for a witness. But what you are seeing is actually a room crafted out of everything which pre-existed. Please go ahead.
Stands converted into the deposition room, which has to be very close to the waiting area. It also provides for a variety of seating choices to cater to the requirement of different age groups, just as in the waiting area. For instance, carpets and cushions have been placed for small children. The deposition room is equipped with a 360-degree camera, earphones for the support person, a non-obtrusive mic for the witness, and LED facilities for identification purposes. The victims
Ajit, bro. पीछे जाना. See this, all this electrical apparatus.
ये तो उनकी गलती है, वाइट लाइट वाला नहीं नेट आ रहा है ना नेट नेट आ रहा है उल्टा नेट बन रहा है ओके देख सकते हो आप
The vulnerable witness deposition complex is pictures or photographs on the walls. The pantry supplies filtered drinking water, facilities for is equipped with a 360-degree camera, earphones for the support person, a non-obtrusive mic for the witness, and LED facilities for identification purposes. The victims are accompanied by a support person. In the attached courtroom, the judge takes the questions from the prosecution and the defense counsel. These are electronically conveyed by the judge to the victims are accompanied by a support person. In the attached courtroom, the judge takes the questions from the prosecution and the defense counsel. These are electronically conveyed by the judge to the support person, who is provided with earphones. These are put by the support person to the vulnerable witness, which are then answered by the victims and at the same time conveyed to the court using a mic and a 360-degree camera. They are viewed on the LED screen installed in the court. The entire deposition room and witnesses are thus fully visible and audible to those in the court throughout the proceedings. The vulnerable witness deposition courtroom has been crafted from existing courtroom infrastructure. The elevation of the dais is lower as compared to the normal courtroom setup. This is to allow the judge to not be in a position of daunting authority over the people in the courtroom. In case a victim seeks to depose from the courtroom itself, seating
That also can be done. You must be wondering who is the support person. If you have seen the guidelines which the High Court must have circulated to each one of you, we see that the guidelines provide for a support person for the victim and or the witness. The support person could be anybody, a relative, a parent, or we have in Delhi used legal aid lawyers to whom, when we have maintained a roster of these legal aid lawyers, we've assigned the fees that they would be paid for doing this kind of work, and they are a valuable, very, very valuable resource in assisting the court. So the court takes the questions from the defense lawyer or the prosecutor and conveys them on electronically, means using a mic into the earpiece that you saw, which the support person is wearing. The support person asks the same question to the victim, and the victim answers that. The 360-degree camera ensures that everything that happens in that room is fully visible in the courtroom. So nobody can, tutor, guide, or anything the witness in any manner. That is the purpose of the 360-degree camera. It's conveyed into the courtroom on the LED in the courtroom continuously. And if you can't get LEDs, start using your laptops or the PCs which your stenographers are using. Those can be used to convey what is happening, the way the trial is conducted. Same way, questions by the defense put to the court and they're conveyed to the support person. This procedure you may think is very cumbersome and it delays the trial. It does not. It is working very well. In where I began with one courtroom, now every district complex has 4, 4, 5 vulnerable witness deposition courtrooms, because the number of cases of sexual violence is so great. POCSO, has so many children who are needed to, whose evidence has to be recorded. So therefore, I think this work needs to be undertaken on a war footing. Any question that you have on this, please ask me after this. Now we are going to show you what we did when the witness wanted to be in the court. The accused, if the witness is in the vulnerable witness room, which is the judge's chamber converted into a witness room, then the accused can be anywhere in the courtroom. There's no difficulty. But this is what we do when the witness wants to be inside the room with the support person.
for the support person and the witness is provided within the courtroom. Provision was required to be made for the segregation of the accused. This was done by creating a door and window with one-way glass in the adjacent Ahmad's room to enable the accused to see into the court, but not the other way round. The one
I hope this video makes it clear. There's an Ahmad room right next to, I don't know what we call them in Kashmir, Ahmad only? No, Nazir support for, Ahmad only. Nazir is in a criminal court, but civil court mein Ahmad hi bolte. So the room was next. You may not have an Ahmad room, but in the Kakaduma we had the Ahmad room. So we locked the room, the door which led to the outside, and we created a door from the courtroom into that room and put in this window with a one-way looking glass. You can only look out into the courtroom, but you can people in the courtroom can't see what is here. So the process adopted was that the judge will sit on his or her chair. The accused would be brought in and put in this room. This room has an intercom to enable the accused to talk with his lawyer. There are speakers provided for the accused to be able to hear the proceedings in the court. And as you can see, if you see from the glass, you can see inside the courtroom. That red sofa in front is where the witness is seated and the support person. So there, the trial is conducted in full view of the accused at all points of time.
One-way glass ensures a complete view of the witness and court from the offender's side, but not from the other side. This enables a balance between witness protection and fair trial. In the space for the accused, a speaker is provided to enable the accused to hear the court proceedings. An intercom also stands installed so that the accused can converse with the defense counsel. This video provided a walkthrough of the vulnerable witness deposition complex in the Karkaduma courts, Delhi. If in your court complex you do not have a room adjacent to the courtroom for creating the offender's room, you have a very easy option available.
So what we did where we didn't have space, Saket has smaller courts. Saket is the most modern, newest court complex in Delhi. Out of the 7 district complexes, we separated a place on the backside of the courtroom of 5 feet by 7-8 feet wide space and put this one-way glass. And we brought the accused in the same manner into the, as we did in Karkaduma, after the judge was seated, the accused was brought in and put in the space. Same facilities are available here. Speaker is there, intercom is there, and the accused has a full view of the courtroom.
You can hive off a portion of the courtroom on any side using the same glass partitions as has been done in the Saket district courts in Delhi. The process thus entails the accused being taken into the room after the judge is seated. Thereafter, the victim is brought into the courtroom and placed next to the support person. This facility should be in close proximity, rather in the same complex as the trial court. If this is not so, valuable judges' time shall be lost when they are required to go to another building for each vulnerable witness. In Delhi, the witnesses are being picked up by the person from their homes. In conclusion, it is re-emphasized that minimum adaptation and resource utilization was required for the creation of these facilities. The idea is so simple that every judge can create a temporary vulnerable witness deposition courtroom using his or her own courtroom and chamber, along with simple e-tools like their laptops or personal computers, earphones, and mics. Evidence of every vulnerable witness in any case should be recorded only in such manner. It is stressed that you don't have to wait for elaborate constructions or equipment for implementing the object of the program. Please remember that such special facilities are the need of the hour. Even while you are undertaking the process of creation of the deposition complex, there are temporary measures you may consider immediately. These include, firstly, an audit and identification of cases involving vulnerable witnesses. Secondly, providing a support person to such witness for which you may train lawyers listed by legal services authorities. Thirdly, permitting separate passage and waiting area to the vulnerable witnesses. Fourthly, using a screen, for example, a portable partition, for segregating the victim from the offender and other persons in the courtroom. Every such measure is one step forward towards the guarantee of equality and access to justice to every vulnerable witness while ensuring a fair trial to the accused.
So I think that video was very clear, and I think you would have realized what a simple tool it is and what a long way it will go to ensure justice to victims of serious crimes, including disabled witnesses, witnesses who are in need of protection, and victims of sexual violence. It's very, very important, and sensitization, I believe, has to come from top down. So if we sensitize our systems, there is no way that the others, the doctors, the police, will not be able to adopt and adapt and conform to the guidelines framed by the Supreme Court of India and by the Government of India so far as medical examinations are concerned, and ensure justice to victims of serious crime. The guidelines you would have seen, there are 4 slides. I think we've run over the time. Provision has been made for support person, facilitator, guardian ad litem, as well as legal aid. What Suzette Jordan was speaking of. One very important provision is a pre-trial visit to the court complex. This means that nobody knows the procedure. A victim doesn't know what she is expected of she or her, what she should expect when she is brought to the courtroom. She or he, it could be a small boy also. So, pre-trial visit is provided for, and in this pre-visit, the procedure is explained to the person, where they will be seated, how it is to be done, and there is an interaction with the judge and the prosecutor. There is concealment of witness identity, development of appropriate questioning, use of screens, etc. And what is important is that the guidelines provide that no adverse inference will be drawn against a party for the use of special measures by the witness. Competency also is to be recorded similarly. There are also other recommendations regarding giving high priority and expeditious handling of these cases. Please remember that children give evidence piecemeal. A child will not tell you everything that happened in one go. You may need to adjourn a case, but if you have to adjourn the case, please accommodate the child's special needs, that she or he has to attend school, and fix the cases on dates and times as are convenient. Then recognizing the special needs. These are all in the guidelines which have been circulated and which we expect. This is something which most of our witnesses face. The lawyer forcing a witness to answer just the question that was asked and volunteer nothing. Children were very upset with this. These are some best practices. This you will need to see. The success of the program of recording complete evidence of a witness depends upon judicial leadership. You have to actively engage with the witness in the pre-visit and in the court appearance and during testimony and court cross-examination. And judicial intervention must ensure that the vulnerable witness in the courtroom is treated with dignity and respect. The questioning is fair and is developmentally appropriate, and self-respect of the witness is preserved. I've already spoken to you about the barriers, and which I don't think I need to repeat again. But the barrier, of course, is the judges' sensibilities. So we have to be more forthcoming. Perhaps the Judicial Academy will run some courses on training in cases involving sexual violence, identifying bias and overcoming the barriers. I think I will conclude and leave you to think over what we have discussed today. If anybody has any questions, you're free to ask. I'll go back to my seat. We can take the questions from there. But once again, I would like to thank the High Court of Jammu and Kashmir, Honorable the Chief Justice, Mr. N. Kotiswar Singh, Mr. Justice Sanjay Dhar, who's the leader in this vulnerable witness program, and the other members of this committee in having given me this opportunity. I'm very grateful to all of you. I didn't realize today was a holiday, and that's why I fixed it at 3 o'clock. If I'd known today was Mr. Hari Singh's birthday, I may have done this in the morning so that you could have enjoyed your holiday as well. But we had already scheduled the program at 3 before I came to know that today was a holiday. But thank you, all of you, for having taken out valuable time. Precious. Holiday time is very precious for judges. We work at, I used to work at 24/7 routine. I know that. Once a judge, always a judge, so long you're in office. So I hope this presentation was of some utility and you've been able to understand what we are aiming at and why it's so important that we get into this system. My brag everywhere, wherever I'm training across the country, is Delhi has such courts and Kashmir has them. I had also inaugurated such courts in Ganderbal and one more place, I think Badgam, if I'm not mistaken, but I may be wrong. But there is no reason why in Kashmir, in every district, we should be able to say that we've been able to craft out. Why every district, in every court complex, we are able to craft out, if not permanent vulnerable witness deposition rooms, at least temporary. Maybe on a, you can say Saturday, we will record the evidence of vulnerable witnesses only, or on a Sunday, or after 4 o'clock, or after 5 o'clock. Use 2 hours, 3 hours to craft out, record the evidence, convert your own courtrooms. There are several, I know district courts, where municipal courts where there's only a single court. So you will say, if we convert that into a vulnerable witness deposition court, how will we do the rest of the work? You don't have to do that permanently. You can use that as a vulnerable witness courtroom on certain days and as the regular courtroom on other days or as part of a day. So these are my suggestions to you. I look forward to engaging more with you. I hope I'll be called back for other programs. I would like to revisit the courtrooms which are which are going on, which are still in use in Samba and in Srinagar. But it was extremely empowering for me to be inaugurating the court in Kashmir, in Srinagar. That's the first one we did in Jammu and Kashmir and Ladakh after coming to the then state and now the two UTs. I look forward to the opportunity on visiting Ladakh as well as Kashmir again for inaugurating and doing more such programs and meeting all of you. That is more important. Thank you very much.
Thank you, Ladyship. The participants are sure to gain valuable knowledge from the guidance received on the subject.
If anybody has any questions, please.
I request the participants who have joined online and through the virtual mode, if they I request the participants who have joined through the virtual mode, if they have any query or any question to ask, they may please proceed.
Hello.
Hello.
They are connected.
Hello, good evening. Ma'am, I have a question. Hello, am I audible? Is there any standard room size for vulnerable witness person, ma'am?
Please give your identification.
Ma'am, this side Khadim Hussain, ma'am. I'm an engineer, ma'am.
Engineer, yes, please ask.
Is there any standard room sizes for definite rooms, ma'am, like the courtroom and the
Yes.
vulnerable witness deposition rooms?
Good question, Khadim. I was visiting Tamil Nadu and they asked me, the engineers asked me to see what they have built. They were very proud of what they had built. When I went to see what they had done, you see, the size of the courtroom was bigger than the Chief Justice's courtroom. You know, and this, we are only going to record. See, you will have see the number of people. I am yet to evolve a size. But if you want a standardization, I will leave it to the space that you have. You will have a judge, you will have the judge's reader, you will have the judge's stenographer. Then you will have a prosecutor, then the prosecutor will have an investigating officer. Then you will have a defense lawyer or maybe one. You can provide for 5 defense lawyers or 10 defense lawyers, an accused person, and 2 chairs. So, you know, you see, you draw and you see how much space you need. You can send it to me, I can evaluate it for you. My email ID is I will ask them to post my email ID on the chat box. अजीब डाल सकते हो? हमारी email ID इनको chat box में डाल दो. If you put my email ID in the chat box, you can send your plans for approval. I will approve them.
Thank you, ma'am. Thank you.
It is geetamittaloffice@gmail.com. GITA.
Thank you so much, ma'am.
But very, very pertinent. I'm glad you asked this question. So it took me 3 hours to explain to the engineers how to change that single court into 6 courtrooms. It was so big.
Yes, ma'am.
It is not to be used for a full-fledged trial. It's only to be used for recording the evidence of one witness.
Okay, thank you, ma'am.
I can't remember how many courts you have in the district court complex in Leh, but probably you could convert two only. Oh, so you need an additional room then. If you have only 2, and there's so much space in Leh, so you can craft out an additional, room with the.
We are constructing a new court complex in Kargil, ma'am. So that's why.
Have you provided for the vulnerable witness court
Yes,
complex?
ma'am. We had proposed a revised drawing for a vulnerable witness portion, ma'am.
I see. Okay. I was proposing to come to Leh in October, but I'll postpone it slightly now. I have to go to Manipur now. You see.
Accommodate in the existing court complex. Complex for this vulnerable witness.
No, don't make a separate complex. It has to be attached and part of the same complex, district court complex.
Okay, ma'am.
Same building.
We had proposed a vulnerable witness portion center in same building, ma'am.
Yes. Very good. Yes. Any other questions?
No, ma'am. Thank you. Thank you so much.
Anybody else? Yes, there's a question in the room. Do you have a mic? No. He's asking. We have a mic. No? There's something on the screen also. Just
Here or not, because there are both the accused as well as the victims are the vulnerable, and can we put the barrier over there for the statements recorded in the court?
you can create spaces like the vulnerable witness deposition spaces for the witness victim. The position, whether it's a child or an adult accused and a child or an adult victim, the position would be similar. You need to separate the victim from the accused. Purpose objective is to separate. So please see how you can do that. We've already made this courtroom available to JJBs. If you saw the categories, I'd recommended to the Supreme Court that this should be used in other cases also, children's courts, JJBs, etc. So Supreme Court, Supreme Court, as Justice Dhar pointed out in the April order, has accepted. So please read the 2 orders of the Supreme Court in Stuti Tukaram and the guidelines. All of you must read the guidelines. Perhaps we can do an online training on the guidelines itself, And if there's any questions, I will have the academicians who help me frame the guidelines and the lawyers. The drafting of the guidelines was also a very consultative and elaborate process. It was again an international effort and a pan-India effort that we put in. So we'll put it together for you.
Thank you, ma'am.
Yes. Ehsan Malik was wanting to ask a question on this.
Mr. Ehsan Malik? Mr. Ehsan Malik, you may please ask the question. Mr. Ehsan Malik, are you still joined? Perhaps, ma'am, perhaps he's disconnected at the moment. Any other participant in the auditorium or through the virtual mode may please ask the question? Please.
Uh, I have an experience to share. Perhaps wouldn't have been a better occasion to relate my experience as a lawyer in handling a case to what, while I was in the course of listening very carefully to your address to the audience. In my early days of my practice,
For those who can't see, this is Justice Rahul Bharti speaking.
during my course of early advocacy days, I got an opportunity to handle a case of a girl child who was a victim of motor vehicle accident. She had suffered, she was an 8th class student coming from a very poor family. Her father was an ex-soldier. She suffered crushed foot injury, got trampled by the school bus. During course of her hospitalization, gentamicin overdose resulted in hearing loss. Now, when I made that claim petition in 1990s, mid-1990s, and all of us can visualize the state of things during 90s. When it came to the matter of her examination as a witness, I found myself physically and mentally drained that how to present her, how to make her comfortable in the MSCT, so rushed place to get the attention of the presiding officer, to give her special time. And it took me more than 6 months to train her in my chamber on daily basis, that today one question, so that she can take the time to know that what she is going to be there in the court, in the tribunal's courtroom. Now, she was just a victim of a motor vehicle accident. Now I am visualizing that how it takes to be a victim of a crime, for a witness to be there, especially the children, minor children, or for that matter even an adult also. So now in 2023, I am going back to that time, that yes, to be a person in same position, it requires the whole institution backing that person, that be comfortable, we are here to take care of it. And it had taken 3 days for examination in chief to be completed, and more than 4 adjournments for her cross examination to be concluded, in which she lost her way. Rather, I could feel her frustration that where she has been brought. Her father would always be jittery upon her, that you are not answering. She couldn't hear it, but she could read the emotions of her father. So perhaps it's a very befitting occasion today, what Your Honor has addressed to us, that just feel like that what a vulnerable witness is, then these courtrooms would themselves correct from the mind of a judicial officer. To what extent I have to go to make that witness comfortable, and then we have to create this mental vulnerable witness box in our own mind, then it would come physical.
Actually, the difficulty is that we have so many cases. When you sit in your courtroom and you see a list of 100 cases before you, all you're concerned is about reaching number 100, and therefore it's not an easy task. We have to overcome a lot of barriers in our own mind. I forgot to tell you people, it was on the slide, but in my hurry I overlooked. When I took over this work as a committee, the first thing that I did was we crafted rules for appointment of interpreters by trial courts as well as translators. You may need translation from Ladakhi to or Kashmiri into Hindi or English, or Dogri into Hindi or English. But in the rest of the country, the constitution initially recognized 28 languages, and there's so many dialects all over the country. So you need translators, but more serious is interpreters. We are talking of what Bharti has just spoken about is a speech impaired or hearing impaired person. So they automatically become speech impaired also, because they can't hear. But you had for the hearing and speech impaired people, you have sign language. Now, there's no national or international sign language also. Every person who cannot speak or is using a different form of a sign language by which they convey what they are trying to say. Now, probably there's a little standardization. So then you have people who are who are blind. Now I ask this question of every lawyer I meet: can a blind person be a witness to the execution of a will? So I'm not going to answer you. I'll leave you to think whether he can be a witness, he or she can be a witness to the execution of a will or not. But very significant. A mentally challenged child is raped, and she identifies one person as a perpetrator. She comes as a witness before you, and even in court, she identifies the same person, the accused, as the person who was guilty. Will you accept her identification or not? Most of us will have a doubt. How can a mentally challenged person, a mentally retarded person, how can such a identification be believed? Now, if you think of it from another perspective, you think of it from the perspective that same mentally challenged person knows who the mother is, who the father is, who the sister is, who is everybody loves her. If she can identify people who love her, why should her identification of the person who has inflicted the worst kind of pain on her not be accepted? So, we have to look at the prism of the mentally challenged person from the special circumstances in which he or she is placed and relate to the evidence in that manner. So these are very, very important factors which perhaps I would request Brother Sanjay also to look and see if you can prescribe the rules for interpreters and translators. I can send you the Delhi rules, and you would need to prescribe the fees we fixed was in 2012, so very minuscule. You may need to upgrade the fees and see the availability. But for these kind of recording the testimony of such witnesses with special needs, you may need a mental health expert, a sign language expert. So these are issues which are before you, and they will come before you at one time or the other. As of now, disability is a topic which is very ignored. We don't want to engage with it as if it is non-existent. You treat them on the periphery till it affects us personally. So but let's begin by mainstreaming it, recognizing it in our courtrooms, and ensuring not only physically accessible spaces but also mentally accessible spaces to every victim. Thank you. Any other questions?
Well, I humbly thank.
Just one minute.
Which must be lurking in everybody's mind is with regard to the identification of the accused, because we are screening the accused from the victim. Accused can see the courtroom, what is happening in the courtroom, but accused is not being seen by the victim. So, question of identification, how to address it,
Yeah.
how it can be done.
So this is and the video showed you that there's an LED in the witness room also. So when this identification has to be done, then you arrange the same TIP formula in the courtroom. You'll have 6, 7 mix the accused, and the victim will be shown this on the LED, and she will identify. So that is how it will be done. That's why you have the 2 LEDs. Otherwise, there's no need for having an LED in the witness assistance room as well. So the basic constitutional requirement is that every criminal trial has to be in the presence of the accused. That we have ensured. And all this came before the IT Act, before all these interventions came statutorily, Evidence Act amendments. We have, before e-courts came into existence. Now it's very easy. So much facility, so much equipment is available all over to every courtroom, every judge. And this must be used to create facilities which really help in the administration of justice.
I humbly thank Honorable Mr. Justice Rahul Bharti for sharing his experience with us, which would sensitize us all to the pertinent question of ensuring care and comfort of vulnerable witnesses. I thank all the participants for their active interaction, which would settle the queries of others also in the process. I thank you, Ladyship. The participants are sure to gain valuable knowledge from the guidance received on the subject of today's program. I now humbly request Honorable Mr. Justice Mohammed Akram Chowdhary, Member Vulnerable Witness Deposition Committee for UT of J&K, to propose the vote of thanks.
Honorable Ms. Justice Geeta Mittal, former Chief Justice, High Court of Jammu and Kashmir and Ladakh, and Chairperson, Vulnerable Witness Committee, constituted by Honorable Supreme Court of India. My brothers, Justice Sanjay Dhar, Justice Puneet Gupta, Justice Rahul Bharti, Justice Rajesh Sekhri, officers of the Registry of the Vulnerable Witness Committee, constituted by Honorable Supreme Court of India, officers of the Registry of High Court of Jammu and Kashmir and Ladakh, judicial officers of Jammu and Kashmir and Ladakh, officers from the civil administration and police, legal aid employees, lawyers, architects and engineering staff of Department of Public Works, participants, guests, ladies and gentlemen. It is indeed a moment of great satisfaction and accomplishment for the High Court of Jammu and Kashmir and Ladakh to organize this training program on conversion of courtroom into vulnerable witness deposition center under the aegis of the Vulnerable Witness Committee constituted by Honorable Supreme Court of India. And I am deeply thankful to Honorable Ms. Justice Geeta Mittal, Chairperson of the committee, for choosing Jammu as the venue for holding the program this time. Last year, an introductory training program for the stakeholders of Kashmir Division regarding the object and scheme of the Vulnerable Witness Deposition Complex was convened at Srinagar, but today's program has been selectively crafted to guide not only the judges, but also the legal aid lawyers, architects, officers, and engineering staff of Public Works Department regarding the object, spirit, and purpose of the project, and facilities which are required to be created. On the occasion, I consider it my good fortune to extend my warm greetings and heartiest gratitude to everyone who have made it convenient to attend this program physically as well as through virtual mode. In his book, The Idea of Justice, eminent economist Amrita Sen points out, and I quote, "What moves us reasonably enough is not the realization that the world falls short of being completely just, which few of us expect, but that there are clearly remediable injustices around us which we want to eliminate," unquote. In the scheme of administration of justice, witnesses are imperative aids and are often described as the eyes and ears of justice system. Therefore, it is quite obvious that we proactively respond to the vulnerability aspect and the distinctive requirement of each vulnerable witness in an effective manner without any further delay. Honorable Supreme Court has always been the flag bearer in introducing reforms in the justice system, and it is quite heartening to learn that witnesses, more particularly of the vulnerable character, are under the protective umbrella of the apex court of the country. The Vulnerable Witness Committee, chaired by Honorable Ms. Justice Geeta Mittal, which has been constituted by the Supreme Court, is making every effort to ensure that courtrooms are a safe and comfortable place for the witnesses. Today, I express my sincere thanks to Chief Justice Geeta Mittal for sparing her valuable time and for gracing the program. As the Chief Justice of High Court of J&K and Ladakh, her Lordship had made significant contributions for shaping up the legal services program across both the Union territories. Her compassion for the weak and vulnerable is well acclaimed. And we are indeed fortunate to have received her guidance in conversion of courtrooms in vulnerable witness deposition centers. We are indeed thankful to you, my Lord. Ladies and gentlemen, in the year 2019, the High Court of J&K, under the leadership of Chief Justice Geeta Mittal, witnessed a watershed moment when the first of its kind Vulnerable Witness Deposition Center was inaugurated at Srinagar by Chief Justice herself.
Later in time, more vulnerable witness deposition centers were established in court complexes in J&K. In context, I may recapitulate from memory that during my tenure as Principal District Judge at Samba, Chief Justice Geeta Mittal had inaugurated Vulnerable Witness Center at Court Complex Samba in the month of September 2020 from Srinagar. The facility, as I recall, served its purpose of ensuring safe and secure environment for the vulnerable witnesses from where they could depose fearlessly without any brooding pressure. We have certainly come a long way from taking the initial steps in the direction till present day. Yet much remains to be done to chase and achieve the objective. Foremost, the existing facilities have to be updated constantly in terms of infrastructure, technology, and capacity building of human resources. And then new centers are required to be established in all courts in both the UTs of Jammu and Kashmir and Ladakh, either by making alterations in existing court buildings or by raising fresh buildings dedicated for the purpose. Our togetherness today indicates that we are united in our unwavering resolve to ensure the meeting of the objective. Let us look forward to fruitful outcomes for this training program with sincere hope and trust that the best legal minds and technical expertise of our engineers would work in unison to ameliorate the pain of vulnerable witnesses and for maintaining public confidence in the criminal justice system. In the journey, we must constantly confront ourselves with the question as to how our action would impact the most vulnerable person who comes as a witness in the court, and are we being able to inspire his confidence and trust in the justice delivery system? If we find an answer and a positive one, we are on the right track. It is a perfect opportunity to express gratitude to Honorable Mr. Justice N. Kotiswar Singh, the Chief Justice of High Court of Jammu and Kashmir and Ladakh, for his consistent guidance in the execution of the program. As I express my sincere thanks, I hope that his vision will continue to guide us in all future endeavors. I am profoundly thankful to Brother Justice Sanjay Dhar, Chairman, Vulnerable Witness Deposition Committee for UT of J&K, for his active interest, encouragement, and support in planning and supervising the arrangements for the training program. His valuable leadership inputs have always been useful, and we thank him for all sincerity for his contribution. I take this opportunity to sincerely thank Brother Justice Rajesh Sekhri, Member Vulnerable Witness Deposition Committee for UT of J&K, for his valuable contribution in organizing the program. His Lordship's practical suggestions stemming from his vast knowledge and experience in the field are truly valued. I owe a deep sense of gratitude to my brother judges at the High Court for their gracious presence, which has added meaning to this program and indicates our collective resolve to ensure safety and comfort of vulnerable witnesses in courts. We are indeed grateful to the participants, including more than 100 who have joined through virtual mode, who have evinced keen interest in this program. Let us understand that the setting up and functioning of these centers is a collaborative effort, and I sincerely hope that the cooperation and coordination between all stakeholders shall accelerate the pace of attainment of the object of this program. I thank you once again for your participation in the program. The holding of this training program has been made possible by the dedicated and industrious efforts of Mr. Shahzad Azim, Registrar General High Court of J&K and Ladakh, and his team of registry officers, judicial officers from the district judiciary, and staff who have executed the assigned task to perfection. I appreciate your untiring efforts and heartily thank you. Our gratitude is also due to the civil administration and police under the leadership of Mr. Arun Kumar Mehta, Chief Secretary, Government of J&K, and Mr. Dilbag Singh, Director General of Police, for extending full cooperation in making arrangements and ensuring that the facilities extended by them are in place and at our disposal. We also thank the officers of the Registry of the Vulnerable Witness Committee, particularly Mr. Ravinder Dutt Sharma, Registrar, and Mr. Ajit Kumar Jha, Joint Registrar, for rendering consistent cooperation during the preparations of the program. We also thank the in-charge police auditorium and the entire team for providing the logistics and other facilities at the venue. Our words of thanks in advance to the media, both print and electronic, for evincing interest in giving coverage to the program. I once again, on behalf of the High Court of Jammu and Kashmir and Ladakh, and on behalf of its Vulnerable Witness Deposition Center Committee, express profound thanks and gratitude to Ms. Justice Geeta Mittal for her Lordship's illustrious presentation in this training program. Ladies and gentlemen, in closing, we express our sincere gratitude to all concerned. Let us remember that endings are perfect opportunities to mark new and positive meanings, and I sincerely hope and trust that we shall put into action what we take from here and work in collaboration for creating safe and invulnerable facilities in courtrooms where the vulnerable witnesses can depose in the manner which can be aptly described in the poetic words of Guru Ravindranath Tagore, and I quote, "Where the mind is without fear and the head is held high, where knowledge is free, where words come from the depth of truth, where the mind is led forward by thee, into ever-widening thought and action, into that heaven of freedom, my Father, let my country awake." Thank you. Jai Hind.
Thank you, Lordship. The participants who are joining virtually may please submit their Google Forms after this program. As we come to the culmination of the program, I seek the kind permission of the chair to please close the proceedings of the function. Thank you. I request the participants to please join us for tea. Thank you.